Good morning to all of you. Law of thoughts. Friends, we have covered almost all the important points. Of course, 2 or 3 topics are left over in the law of thoughts. In this video, we are going to discuss the concept of liability for dangerous premises. Liability for dangerous premises, otherwise it's called as occupiers liability. Actually, there is a special provision, special act in United Kingdom, Occupiers Liability Act 1957, which says an occupier of the house, an occupier of the chattels, an occupier of the premises, he should even an occupier of the car, an occupier of the aeroplane, a ship, he owes an obligation to the personal safety of the visitors, may be lawful, may be unlawful, may be trespassers, may be invitees, may be licensees, whoever he is. But it is your duty to see that he is not harmed. No legal injury will be done to him. This is the crux of the Occupiers Liability Act. మన ఇంటికి వచ్చేవాడు మంచోడు కానీ చెడుకోడు కానీ మేమేమి ట్రెస్పాసర్స్ అయినా సరే అతని యొక్క బాధ్యత సేఫ్గా తిరిగి వెళ్ళే బాధ్యత మనం తీసుకోవాలి. రైట్? సో ది ఆబ్లిగేషన్స్ ఆర్ టువర్డ్ ద లాఫుల్ విజిటర్, టువర్డ్ ద ట్రెస్పాసర్స్ అండ్ టువర్డ్ ద చిల్డ్రన్ ఆల్సో. ఆల్రెడీ ఐ టోల్డ్ యూ దట్ వెస్ట్ రైల్వే కేస్. Right. So first point is duty towards the invitee. So Cates versus, this is a negative example but you have to learn. Cates versus Mongani Brothers 1917. It happened in Bombay. Mrs. Cates and her daughter, both of them went to a restaurant. They wanted to have lunch and they sat under a ceiling fan. So which fell on her and she was bruised literally. But the management, Mongni brothers, they could be able to prove that they have very recently got it serviced. The defect is latent, it is not visible. So since they have taken necessary precautions, servicing work, you can't hold them liable. It's a mechanical defect. So it is a negative example. Defect cannot be foreseeable by a reasonable man. Right? Second, duty toward the licensee. Licensee means a person who is authorized to enter your premises. So in this case, please remember the case law. Lakshmi Chand Khatsi Panja. So Lakshmi Chand Khatsi Panja versus Ratan Boy 1927. Actually, some of you are residing in rented houses, some of them own houses. So when you are residing in a rented house, normally you will always be having problems with the owners. So there was a structural defect in the building. It was known to the owner. The residents or the tenants, they requested him to rectify the defect, but he did not take care. What is the dabra? Building account vadike bette tarvata chuddam antaru. Ultimately, on one day the structure fell down and one of the tenants in the fourth floor, he was killed in the mishap. So definitely the owner, landlord is held liable because he has got a duty towards the safety or liability of towards the residents, or they are all licensees. Another case, mana negative example kalthunam. Fairman versus Perpetual Investment Building Society 1923. Actually, in this case, the plaintiff went to his sister's rented building. He wanted to stay for 1 day or 2 days. He doesn't know the structure or the akada. Straight ga cheppalante staircase lo problem. ఈ స్టేర్ కేస్ అందరూ వాడటం వల్ల మధ్యలో ఒక చోట గుంట పడింది. ఆ సిమెంట్ ఊడిపోయి పెచ్చు ఊడిపోయి గుంట పడింది. సో వైల్ క్లైంబింగ్ ది స్టెప్స్ ఆర్ వైల్ కమింగ్ డౌన్, ద ప్లెయింటిఫ్ leg, actually her leg going to the variance, there is a depression. The plaintiff's heel got stuck in the depression, due to which she was injured. But the occupier, the owner, is not held liable because it is the fault of the plaintiff in not observing the depression. Therefore, defendant can't be held liable. So, dirigate వచ్చింది. సో సహజంగా అన్ని కేసులు మనకి ఫేవర్గా ఉంటాయి అనుకోకండి. నెగిటివ్ ఎగ్జాంపుల్ బోల్డెన్ వస్తాయి. Then duty towards a trespasser, even though he is a trespasser, means who comes on your land without invitation of any sort. So Sundari versus Union of India 1971. Sundari's husband, who was a season ticket holder, was injured and he died while crossing the railway level crossing gate. Because while crossing the railway level crossing gate, he did not observe the other side coming engine and the engine hit him, due to which he died instantaneously. Even though he was a ticket holder, the railways held that he was a trespasser. Therefore, railways are not liable. Suppose if you are going to the upstairs, మామూలుగా రైల్వే ట్రాక్ దాటి అవతలకి వెళ్తే పర్లా, క్రాస్ చేస్తే ఎట్లా, యూఆర్ ట్రెస్పాసర్. ఇదన్నమాట గుర్తుపెట్టుకోండి. And duty toward the children, last point, that is Cook versus Midland Great Western Railway of Ireland 1909. Already we have discussed this case. This is ఏం లైబిలిటీ, అది కాంపోజిట్ కన్నా ముందు వస్తుంది. కాంట్రిబ్యూటరీ నెగ్లిజెన్స్ చెప్పాము మనం, రైట్. సో యాక్చువల్లీ మా ఊరు గుర్తు వస్తుంది, రేపల్లి. ది వాజ్ రైల్వే టైం టేబుల్, బికాజ్ రేపల్లి ఇస్ ద టెర్మినస్, లాస్ట్ పాయింట్ కాబట్టి అక్కడికి వచ్చిన రైలు వెనక తిరగాలి. ఇంజిన్ వెనక తిరగాలంటే ఇలా టర్న్ టేబుల్ ఉంటుంది, దాని మీద తిరుగుతూ ఉంటాయి. So this turntable is not being maintained properly. Children used to come and play. The person who is in the signal cabin, he allowed them. They are licensees. And one day it so happened that one of the children, aged about 4 years, he was injured while playing on the turntable. They filed a case of compensation. Yes, it was held that the children were licensees and the defendant was liable to pay compensation. So with this, I am concluding. Occupiers liability is one of the topics where you can get 2 marks or 3 marks question. Please read the material thoroughly and enrich your legal knowledge. Thank you very much.